Welcome to the 24th Annual University of Michigan Senate's Davis Markert Nickerson Lecture on Academic and Intellectual Freedom. I'm Peggy Hollingsworth, President of the Academic Freedom Lecture Fund, and was Chair of the Senate Advisory Committee on University Affairs, SACUA, and the Senate Assembly in the 1990-1991 academic year when the lecture series was initiated. As far as I've been able to determine, this is the longest continuous series of lectures on academic and intellectual freedom at any institution of higher education in the United States. Each year for the past 23 years, a distinguished scholar has addressed us on a topic of great interest and vital concern to the academic community, and indeed, society as a whole. The Senate Assembly's Davis Markert Nickerson Lecturer Selection Committee was extremely pleased when Douglas Laycock, Robert E. Scott, Distinguished Professor of Law and Professor of Religious Studies at the University of Virginia, accepted this invitation to deliver the 2014 Davis Markert Nickerson Lecture. Professor Laycock is a former member of the faculty of our law school and is undoubtedly well known to many here in Ann Arbor. He is one of the nation's leading authorities on the law of remedies and also on the law of religious liberty. Previous lecturers in this series have not addressed issues related to religious liberty and their relevance to academic and intellectual freedom. As I have mentioned in past years, today we desperately need Americans of all ages who will join the battle to preserve the academic and intellectual freedom which has existed in our academic institutions and has been of benefit to the citizens of this country. We need a new generation of individuals who possess the enormous courage that was demonstrated by Professor H. Chandler Davis when in November 1953 he stood before a subcommittee of the House Un-American Activities Committee and claimed his First Amendment rights. Professor Davis is one of 3 former faculty members after whom this lecture series is named. He is here with us today as he has been here every year since the first Davis Markert Nickerson Lecture. Chandler, will you please stand so we can recognize you? As you might be aware, there are many who not only have made these lectures possible, but who also have made them so successful. At this time, I would like to acknowledge them. The University of Michigan Faculty Senate Assembly adopted the resolution that established the series. The American Association of University Professors, AAUP, provided a grant to support the first lecture with the proviso that our faculty match the grant. And the directors and members of the Academic Freedom Lecture Fund over the years have ardently supported the cause of academic and intellectual freedom and have given whatever they could afford to sustain and promote the series. Some academic and administrative units of the University of Michigan today provide support, both in money and in space for the lecture series, as well as the organizations and groups listed in your program. The advisory board of the Academic Freedom Lecture Fund and the past Davis Markert Nickerson lectures have had a key role in the recruitment of the distinguished scholars who deliver the annual lecture. We have the good fortune again to have with us today Jared Wadley, Senior Public Relations Specialist, who has, for the past 6 years, written excellent articles about the annual lecture for the University Record. As he has done for many years, Scott Mann, now an independent video producer, will record the lectures so they can be seen by those who cannot be with us today. The video of today's lecture and all other lectures since 2001 can be viewed by going to the Academic Freedom Lecture Fund website. Ryan McDonough, Publicity Director, who is here with us today, of WLTV, and a junior undergraduate with a major in English and film in the LSNA Screen Arts and Culture program, interviewed Professor Laycock earlier today. This interview will be broadcast on Channel 55 to all campus buildings, including the dormitories. While organizing the lecture this year, it has been especially enjoyable for me to work with Gregory Endenbergen, Speaker Chair of the Student Division of the Law School Federalist Society, with whom Professor Laycock also met earlier today. Our speaker has been very busy. The staff of the Faculty Senate Office, Thomas Schneider and Robin Snyder, with whom I have worked and enjoyed, and the students who work with them provided the necessary staff and logistical support. This year, we are assisted by Christopher Elrod and Kendrick Bell, an undergraduate LSNA student in economics. As in previous years, Brent J. Futrell, our graphic artist, has created the program and poster that publicize this lecture. I would like to also congratulate Regent Kathy White, who is sitting in the rear here, who has just been re-elected to her position as Regent at the University of Michigan. Finally, an announcement about the 25th Annual Davis Markert Nickerson Lecture, which will be a symposium and will take place on October the 8th next year, is included with your program. And now, University of Michigan Provost and Executive Vice President for Academic Affairs, Martha Pollack, will introduce this year's University of Michigan Senate's Davis Markert Nickerson Lecture on Academic and Intellectual Freedom. Provost Pollack.
Thank you, Peggy. Good afternoon. It's my pleasure to join you and everyone assembled here today for the Davis Markert Nickerson Academic and Intellectual Freedom Lecture. Since the first lecture in 1991, the Academic Freedom Lecture, as it is commonly known, has become an important event on campus. Over the years, a distinguished group of scholars, jurists, and journalists have delivered lectures that have explored changes in society that raise challenges for traditional notions of academic freedom. They've examined tension between national security and the public's right to know, and they've offered judicial perspectives on questions related to academic freedom. The Davis Markert Nickerson Lecture has particular salience this year, as the academic world has been engaged in vigorous debate about the right of public figures to present their views in on-campus forums, and about the right of students, faculty, and others to protest and even block such presentations. I'd like to take a moment to recall some of the events of the McCarthy era in the 1950s, a period during which many individuals were, of course, afraid to speak their mind for fear that they might be branded as communists or communist sympathizers and face serious consequences. In 1954, the United States House of Representatives Un-American Activities Committee sent a delegation to several states, including Michigan, to collect testimony about possible subversive activity. University of Michigan Professor Chandler Davis, Clement Markert, and Mark Nickerson were called to testify. They refused to do so. As a result, the university suspended all of them. Dr. Davis was dismissed from the university and was also charged with contempt of Congress. He was indicted and then in 1957 convicted on the contempt charge. After an unsuccessful appeal, he was sentenced to time in federal prison. Leaving prison, Dr. Davis joined the faculty of the University of Toronto, where he's had a long and distinguished career as a mathematician. Dr. Markert, a biologist, was ultimately reinstated in his position in biology here at the University of Michigan. Nevertheless, he left to chair the Department of Biology at Yale. Elected to the National Academy of Sciences, he finished his career as Distinguished University Professor at North Carolina State University. Dr. Nickerson was dismissed from the university despite having achieved tenure here. A pharmacologist, he took a faculty position at McGill University, where he led the department, authored more than 250 publications, and later served as president of the Pharmacological Society of Canada. Each of these scholars made significant contributions in his field of expertise. Each of them also took a stand, protecting the rights of freedom of thought, of speech, and of political activity that are so important to all of us. Each year, this lecture is to help salute Professors Davis, Markert, and Nickerson, and to affirm our commitment to these fundamental principles. These principles are also reflected in the Statement on Academic Freedom adopted by our Senate Assembly in 2010. Today, we are honored to have Doug Laycock with us as the Davis Markert Nickerson Lecturer. Dr. Laycock is the Robert E. Scott Distinguished Professor of Law and Professor of Religious Studies at the University of Virginia. As many of you know, Doug was on the faculty here at Michigan from 2006 to 2010, serving as the Yale Kamazar Collegiate Professor of Law. Prior to that, he taught at the University of Texas and the University of Chicago. Doug is a distinguished legal scholar, an expert on the law of religious liberty and the law of remedies. He has testified many times before Congress, and he has argued cases in many courts, including the United States Supreme Court. Through close examination of laws, both proposed and enacted, Doug raises critical questions about how we balance competing interests. He recognizes that the diverse religious practices of Americans, on the one hand, and governmental interest in regulating those practices on the other, can and do come into conflict. Doug has provided insightful perspectives on contemporary issues that range from the Hobby Lobby Corporation's objection to providing contraceptive coverage to its employees, to a current case concerning a Muslim prisoner's right to grow a beard. Doug's topic today is religious freedoms and the culture war. I'm eager to hear what he has to say on this important topic, and I invite you to participate in a spirited question and answer session when he has finished speaking. Please join me in welcoming Professor Doug Laycock.
Thank you. That was very generous. It is good to be back. I saw a lot of friends today, saw some good students. Did not leave voluntarily, as many of you know. Someone keeps getting new jobs, and I keep following her around. I'm rather attached to her by now. It is an honor to be giving this lecture, and the story that the provost just summarized is a story of heroism, and I'm proud to be honoring Professors Davis, Markert, and Nickerson. I begin with a proposition that may be more controversial than it sounds. I believe that human liberty is a good thing, and especially so with respect to those things that are intensely personal. And therefore, I believe that the free exercise of religion is a good thing, and I believe that control of our own sex lives is a good thing. And one of the ironies of the contemporary culture wars is that religious minorities and sexual minorities make essentially parallel demands on the larger society. They say that some aspects of human identity are so fundamental that they should be left to each individual, free of all non-essential regulation. Sexual orientation is that fundamental, and for many believers, religious faith is that fundamental. Rights to abortion and contraception are one step removed. I don't think anyone says her abortion or her contraceptive is the core of her identity, but the availability of those rights is often essential to one's identity as a sexually active woman who is not to have her destiny left at the mercy of that one activity. Each of these rights is legally protected, but often incompletely and not very securely. Same-sex marriage is now the law in 30 states. It seems to be coming to the rest, but that's not yet guaranteed, and there is no ban on sexual orientation discrimination at the federal level or in most of the red states. Abortion is a bitterly disputed constitutional right, and the Supreme Court has allowed more and more hostile regulations that hamper the exercise of that right. The current law of religious liberty is more complex and probably less familiar. The right to believe is absolute. The right to speak about religion is generally well protected, but not absolutely. More controversially, religious liberty includes the right to engage in religiously motivated activities. In the language of the Constitution, to freely exercise a religion. A right to believe a religion, but no right to act on its teachings would be a hollow right indeed. It would be like protecting sexual orientation, but not the sexual conduct based on that orientation. But actions can be protected. They cannot be protected absolutely. We all impose cost on our neighbors with most of what we do, but there have to be limits on that, and we cannot inflict significant harm on our neighbors, even in the exercise of a constitutional right. Sometimes religious actions are protected simply by not regulating, and the practices of politically dominant religions have never been unlawful. Some actions are generally unlawful, but when they're done for religious reasons, they are protected from regulation by religious exemptions. Sometimes that's entirely uncontroversial. It's unlawful to give alcohol to children, but no one thinks that should be applied to communion wine or Seder wine. And that kind of regulatory exemption has been part of the American experience of religious liberty since the 17th century. The Carolina colony exempted Quakers from swearing oaths in 1669. Rhode Island exempted them from serving in the militia in 1673. Religious liberty has enabled people with fundamentally different views on fundamental matters to live in relative peace and equality in the same society. Today, a substantial body of law protects regulatory exemptions for religiously motivated behavior, but it is a confusing and rather ragtag body of law. A First Amendment that protects only sometimes under a deeply ambiguous Supreme Court decision, little-known religious liberty guarantees in state constitutions, broad statutory protections for religious liberty and religious freedom restoration acts, known as RFRAs, at the federal level and in 19 states, 2,000 or more specific exemptions from individual state and federal statutes, similar exemptions in many local ordinances, but much of that law, especially at the state level, has been little used and little tested. And all of this law has become far more controversial than it used to be. When Congress passed the federal RFRA in 1993, it acted unanimously in the House and 97-3 in the Senate. RFRA says that government cannot substantially burden a person's exercise of religion unless that burden is the least restrictive means to further a compelling government interest. In 1997, the Supreme Court held the federal RFRA unconstitutional as applied to the states, and Congress immediately set about to enact valid replacement legislation, but those bills were soon mired in partisan deadlock, principally due to energetic demands for a global civil rights exception. And by 2000, Congress abandoned the effort to enact a broad replacement for RFRA. It enacted the two pieces it could agree on: protecting the religious liberty of prisoners and mental health patients, and protecting religious organizations in the zoning process. On the broader bill, we had gone from 97-3 to partisan deadlock in 5 years, and disagreement over religious liberty has gotten steadily worse ever since. Now, a large social and political development of that sort obviously has multiple causes, but the biggest problem for religious liberty today is deep disagreement over sexual morality. Formerly dominant religions are no longer dominant, and for the first time in our history, it is sometimes illegal to practice well-known teachings of our largest religions. We've never had that situation before. So let me review the obvious outstanding issues. After the Supreme Court announced a constitutional right to abortion, the pro-choice movement tried to force religious hospitals to perform abortions. They had some occasional successes in the lower courts, but Congress responded with legislation to protect the rights of conscience. Nearly all states have similar legislation, so no medical provider can be required to perform or assist in abortion or to permit it on an institution's premises. The pro-choice movement doesn't much like those rules. They're sometimes under-enforced, but Congress seems to treat the issue as settled. There's been a long-standing status quo there, now under attack around the edges. The ACLU has sued the Catholic bishops in a Michigan case with egregious alleged facts. A woman whose water broke in the 18th week of pregnancy was allegedly told at a Catholic hospital that no treatment was possible, misled about her condition, about the prognosis for her and the baby, not referred elsewhere. The baby had almost no chance of surviving. The usual treatment would have been to induce labor or otherwise terminate the pregnancy. The woman had no car. The hospital was the only one in the county. Of course, she lost the baby. The futile effort to prolong the pregnancy caused painful and dangerous complications. All of that is according to the ACLU's complaint. The bishop's lawyers say that these alleged facts would actually violate Catholic teaching if true. The ACLU has filed church documents that ambiguously suggest otherwise. The parties are fighting over jurisdiction, and the court is a long way from sorting out the facts. The complaint does not mention the Michigan abortion conscience statute, but it's hard to see how the plaintiff's claim can go forward without asking the court either to invalidate that statute as applied, hold it preempted by the federal duty to provide emergency care, or interpret it in creative and non-literal ways. Invalidation of the conscience legislation as applied to those facts, of course, would not invalidate it as applied to more routine abortions, but no doubt the ACLU hopes to build on whatever success it may have in this case. Now, I don't offer this case as an example of an unjustified attack on religious liberty. If the facts are as alleged, local monopoly, deliberate deception of an unsophisticated patient, known and substantial risk of harm to that patient, There are multiple grounds for rejecting any claim of right for the hospital to do what it allegedly did. The case is relevant today, not because of its merits, but because of its timing. Why was this suit filed now and not 10, 20, 40 years ago? This cannot be the first case with egregious facts. The ACLU alleges that this is at least the fifth such case at this one hospital in Benton Harbor, which of course is not a very big place. I can only speculate that this lawsuit looks viable to the ACLU today, and it did not look viable in the past, and that what has changed is not any controlling or even suggestive judicial precedent, but a climate of opinion that is more skeptical of claims to religious liberty. On same-sex marriage, the disagreement begins with a disagreement over the nature of marriage. Marriage is a legal relationship, and for many people also a religious relationship. The secular side sees the legal relationship as primary. Committed religious believers see the religious relationship as primary. And they see same-sex marriage as the state interfering with the sacred, changing a religious institution. In both as organizations and as individuals, many religious conservatives refuse to participate in same-sex weddings or commitment ceremonies. Some churches will not make their space available. Some clergy will not perform the ceremony. Some individuals in the wedding business will not assist with the ceremony or the reception. Some counselors will not counsel same-sex couples. Catholic adoption agencies will not place children with same-sex couples, and Catholic adoption agencies in 3 states have closed over that issue. Now, the refusal to assist with a same-sex wedding does not imply refusal to serve gays and lesbians as individuals. The religious liberty claim here rests on the view that marriage is inherently religious, and these conscientious objectors refuse to facilitate, validate, or recognize a relationship that in their view falsely mimics a religious relationship but is actually religiously prohibited. Where these conservative Christians see a protected exercise of conscience, gays and lesbians see discrimination that is or should be illegal. They mostly concede, at least tactically and maybe genuinely, that the clergy should not be required to perform the ceremony. They have sometimes acquiesced in bills that protect religious organizations in context beyond the ceremony, but they have kept those exemptions narrow, and they have fiercely and successfully opposed any kind of exemption for religious individuals in the wedding business. Most of these battles have been fought in state legislatures in blue states, where the problem has been grudging and inadequate protections for religious liberty. And now when marriage equality arrives by judicial decision instead of by legislation, the religious minority loses all its bargaining leverage. And the only remaining reason for blue state legislators to protect religious liberty with respect to marriage is that it's the right thing to do. But blue state legislators tend to deny that religious exemptions are the right thing to do. In red states, we often get the opposite problem. Religious liberty bills that overreach, bills that protect religious liberty without also protecting same-sex couples, bills that are explicitly promoted as anti-gay bills. There's also confusion on both sides about what religious liberty legislation can actually do in red states. State religious liberty legislation obviously cannot exempt states or their citizens from federal constitutional law. What it can do is exempt religious individuals and organizations from state and local laws that prohibit discrimination on the basis of sexual orientation. No one has to assist with a same-sex wedding unless there's a state public accommodations law that says so. And most red states do not have such laws with respect to sexual orientation, and they show no current willingness to enact them. Religious liberty legislation without gay rights legislation is fairly attacked as one-sided. It's also attacked as addressing a non-existent problem. Without a gay rights law to back up marriage equality, there is no state law for conservative churches or wedding planners to be exempted from. But red states often have large blue cities that do have gay rights laws. Statewide religious liberty legislation is needed to provide uniform exemptions from those local ordinances. But both politically and in terms of equal liberty, the lack of balance in these red state religious liberty bills is a problem. There was a religious liberty bill in Kansas last spring that overreached so badly that the Republican leadership in the Senate killed it. There was a much more defensible Arizona bill that was vetoed, partly because it was falsely attacked as just like the Kansas bill, partly because its sponsors said anti-gay things that played into that attack. Then there's contraception. which was settled for half a century and now has come unsettled. The Catholic Church long taught that artificial contraception is immoral. Most Americans, and indeed most Catholics, have rejected the Church's teaching as incomprehensible, wrong-headed, or both. But the Church's view was once enforced by law in some states, and the Supreme Court held those laws unconstitutional, and the Church acquiesced. There was no rearguard resistance of the sort that faced the Court's decisions on abortion or school prayer or lots of other controversial issues. And the resulting situation after the Supreme Court's decision nicely illustrates the live and let live solution to such a deep moral disagreement. The great majority thought that contraception was permissible. They used it themselves when needed. They made no effort to force that view on the minority that disagreed. The minority thought that contraception is immoral and they refrained from using it, but they made no effort to force that view on the majority. Each side allowed the other to live by its own values. The Affordable Care Act disturbed that equilibrium. Employers were required to provide insurance coverage that would include contraceptive devices and drugs and sterilizations prohibited by Catholic teaching. This required coverage also includes emergency contraception. And to much of the pro-life movement, both Catholic and evangelical, emergency contraception is sometimes a way of inducing abortion. And that belief cannot be dismissed as just a product of the religious right's fevered imagination. The FDA-approved label says that these drugs work by preventing ovulation, that's just contraception, and that they may sometimes also work by preventing implantation of a fertilized egg in the wall of the uterus. And for those who believe that a new human life is created at the moment of fertilization, preventing implantation is a form of abortion. And it doesn't matter that the drug works that way only sometimes, or that the FDA says only that it may work that way sometimes. If I hand you a gun and I say, it might be loaded, but don't worry, it probably isn't, not one of you would take the chance and fire that gun at another human being. And for just the same reason, if you really believe that life begins at conception, you will not take the chance. Catholic and evangelical institutions will not pay to make available a drug that, in their view, may destroy an innocent human life. In the Hobby Lobby case, the Supreme Court said that a closely held corporation owned by members of a single family who were unanimous in their religious objection is protected by the Religious Freedom Restoration Act. The owners could exclude emergency contraception from their employee health plans. The decision was greeted by extravagant triumphalism among the conservative religious community and an avalanche of hysterical criticism from the left. Bigger things may someday flow from the Hobby Lobby precedent, although the odds seem to be against that. Hobby Lobby itself is an extremely narrow decision. You cannot possibly have learned that from the press coverage of the talking heads. So let me tell you what it actually says. The opinion says that individuals do not forfeit their religious liberty rights when they incorporate their business. It does not say that the commercial context is irrelevant or that religiously motivated businesses will win many cases. Commercial businesses have never brought many cases, and I don't expect that to change. The business won in Hobby Lobby because the government had devised a means for delivering free contraception to female employees without requiring the employer to pay for it, contract for it, or arrange for it. The government developed a solution for religious nonprofit organizations, and the court said it could be made available to a for-profit business too. But Hobby Lobby does not hold that every time the court or every time the government exempts religious nonprofits, it has to also exempt commercial businesses. Rather, what Hobby Lobby holds is that when the government has available a solution that fully achieves its goals, it has no need to enforce a more burdensome solution on conscientious objectors. The court said the impact on female employees would be precisely zero. The government's alternative solution is complex. Here's the short version. Insurers are obligated by law to cover contraception in every insurance plan. If a religious employer certifies that as a religious objector it refuses to provide some or all contraception, then its insurer becomes obligated to drop contraception from the employer plan and to provide contraception itself outside the employer plan with segregated funds and with separate communications. And the insurer recovers its costs by not paying for the avoided pregnancies or with a credit against fees payable to the exchanges. The insurers are required to cover contraception whether or not they receive a conscience objector notice from the employer. What the notice triggers is only the obligation to separate that coverage from the employer's plan. And the notice now goes to the government, not to the insurer. It contains no instructions to the insurer. Some of the religious nonprofits had viewed the government's original form as directing the insurer to do what the church cannot do itself. That language has been eliminated. The form does require the employer to tell the government who its insurer is. Some major religious nonprofits have accepted this solution as sufficient. Others continue to litigate. Ave Maria University just got the first preliminary injunction against having to file even the revised form. That issue was eventually headed back to the Supreme Court, but I think that Ave Maria and similar claimants are ultimately going to lose. They will lose because they demand not just an exemption for themselves, but also that the law regulating their insurers be changed. And they are no longer seeking a cost-free solution. They want a rule that really would deprive their female employees of free contraception. And if they get that, the decision in Hobby Lobby comes unglued, and at least Justice Kennedy does not seem prepared to vote for that. These issues reach into universities in ways that can affect academic freedom. One recurring source of disputes is religious graduate students in the helping professions. There's a graduate student in social work who was disciplined for refusing to sign a letter to the legislature supporting a bill to permit gay and lesbian adoptions. That case settled on terms favorable to the student. A counseling student at Eastern Michigan was expelled for refusing to counsel gay clients about relationship difficulties. She won a favorable interim ruling from the Court of Appeals. The case then settled for a substantial cash payment, but she was not readmitted to the program. Now, that student sought only the right to refer the client to another counselor. There have been others in the helping professions who lost cases and who deserved to lose cases when they insisted on a right to meet with gay clients and try to convert them to heterosexuality or to evangelical Christianity. The opinion in the Eastern Michigan case is devastating to the university. The profession's code of ethics actually encourages referrals as a solution to values conflicts between counselors and clients. There was evidence that such referrals are common, and the rule against referrals turned out in practice to be only or mostly a rule against referrals of gay clients by religious conservatives. Another recurring issue concerns student organizations. On most campuses, the college Republicans, the Environmental Law Society, the gay rights organizations, all the other political or ideological student groups can insist that their members support their cause. And for the same reason, student religious groups often require a statement of faith for voting membership or for leadership positions. But unlike politics or ideology, religion is on the standard list of civil rights categories, protected against discrimination. And too many deans of students have kicked these religious groups off campus on the ground that their statement of faith is religious discrimination, and sometimes sexual orientation discrimination besides. The Supreme Court upheld such a policy a few years ago, 5-4, in an extremely narrow opinion that avoided the central issue, so it remains unsettled. These university policies are simply a category mistake. We prohibit religious discrimination in the university because religious faith or identity is generally irrelevant to the university. But religious faith and identity is definitional to a religious organization. Taking account of religion there is neither irrelevant nor invidious. A religion that cannot make distinctions on the basis of religion will not long survive as a religion. The real religious discrimination in these cases is that committed by the deans of students who seek to drive off campus all those religious organizations who are sufficiently serious to require a statement of faith. Now a bit of a digression. The fundamental French provision on religious liberty closely parallels the fundamental American provision on religious liberty. Free exercise, no establishment, separation of church and state. But France and the United States have come to opposing answers on almost every important question about religious liberty. There is no right to religious exemptions in French law, and few, if any, legislated exemptions. France can and does sometimes single out religion for discriminatory regulation. One example, the recent ban on covering your face in public exempts pretty much everyone except bank robbers and Muslim women. Religious organizations in France must obtain licenses from the state, and on occasion those licenses are denied. There are restrictions on religious speech, and especially on evangelism. The state owns most of the churches and pays for their maintenance. and it pays for religious schools. There's a central ministry of organized religions that negotiates the church-state relationship with officially appointed representatives of various religious traditions. The whole body of law seems designed to keep religious groups dependent on the state and on a short leash. So how to explain these radically different outcomes from essentially the same legal text? The biggest difference is that in France, the church was on the wrong side of the revolution. The Catholic Church opposed not just the revolution's many excesses, but the revolution itself. It supported repeated cycles of counter-revolution throughout most of the 19th century. The church was seen as opposed to the liberties of the people. It made itself the subject of enmity and suspicion and of regulation. In the United States, the churches overwhelmingly supported the revolution. And so in the United States, religion and liberty were perceived as natural allies. In France, religion and liberty were perceived as natural enemies. And those contrasting perceptions have had very different consequences for religion and for religious liberty. Well, the sexual revolution that began, or accelerated really, in the 1960s continues to make important gains, most notably now with respect to same-sex marriage. And conservative churches have persistently been on the losing side of this revolution. And they have opposed not just the sexual revolution's many excesses, they have opposed its core. And each of the remaining sexual issues, abortion, same-sex marriage, contraception, sterilization, emergency contraception, has the same fundamental structure. What one side views as a grave evil, the other side views as a fundamental human right. For tens of millions of Americans, conservative churches have made themselves the enemies of liberty. In the view of the pro-life and traditional marriage movements, abortion and same-sex marriage are so evil that they must be prohibited for everybody. And that means, in the view of pro-choice women, same-sex couples, and their many supporters, that religious conservatives are attempting to interfere with the most intimate and personal of human decisions and to impose their controversial views of morality on the entire population. The contraception issue is different in important ways. It is unimaginable that any American state would now attempt to ban contraception. Here the friction flows from the religious liberty claim itself. Do religious institutions and employers have to cover contraception for their students and employees? The churches, correctly in my view, see any requirement for them to provide contraception as opposing secular morality inside a religious institution. Churches and religiously motivated employers who refuse to pay for contraception coverage are not telling anyone what they can do with their own money. Hobby Lobby gave them only a right to do nothing, neither provide contraception nor interfere with it. But of course, the other side doesn't see it that way. American law has bizarrely made health care an employer responsibility. Religious institutions are refusing to perform. Never mind that the employees signed on to do the work of the church and to further its mission. Those demanding contraception do not see themselves as imposing secular rules on the church. They see the church as imposing religious rules on them. And once you reframe the conflict that way, then once again, the church is seen as interfering with other people's sex lives and with their health care too. Most of these issues can also be put in the frame of discrimination. Churches and believers discriminate on the basis of sexual orientation by not recognizing or facilitating same-sex marriages. They discriminate on the basis of sex by refusing to provide items essential to women's health care. And as I already mentioned, they discriminate on the basis of religion by limiting membership to people who actually believe the religion. Imagine that. Discrimination is a powerful charge. It still retains some of the moral imperative associated with the civil rights movement of the 1960s. And the issues involved in these religious disputes are very different from pervasive racial subordination, but the broad label discrimination makes no distinctions. The stakes in all this are high. Many disputes over the free exercise of religion involve unusual practices of small religions, unusual laws of little importance, or both. But these disputes over marriage, contraception, and abortion involve core teachings of large and mainstream religious organizations on one side, important government programs backed by powerful interest groups on the other side. They present claims of fundamental right on both sides. The right to exercise one's religion and not to violate God's will as one understands it. The right to control one's own sex life, one's own body, one's own health care, one's most intimate relationships. It is a risky step to interfere with the most intimate details of other people's lives while loudly claiming liberty for yourself. If you stand in the way of a revolution and lose, there will be consequences. I do not offer a prediction, that's a fool's game. I do identify a risk. The consequence of fighting the sexual revolution so long and so hard may be to turn public opinion towards a very narrow, French-like view of the meaning of religious liberty. And certainly in the short run, this conflict over sexual morality is making a large part of the population deeply suspicious of claims to religious liberty. Hobby Lobby points the other way. It's a win for the religious side. It protected religious conscience in a somewhat novel context, but it also further inflamed that part of opinion that is skeptical of regulatory exemptions for religious liberty. The pro-choice and gay rights movements see themselves, correctly in my view, as the targets or victims of religiously driven attempts to restrict abortion and same-sex marriage. And they react with very negative views of their religious opponents. They see conservative believers as extreme, unreasonable, bigoted. Many of them believe, and they sometimes say, that the religious side is evil. The conflict over contraception is more recent, but it seems to be generating the same kinds of hostility. For too many on the pro-choice, gay rights, and women's health care side of these issues, the free exercise of religion begins to look like a bad idea. It's a bad idea because it empowers their enemies. It should be interpreted extremely narrowly, confined to a bare right to belief, but it cannot mean a right to act on those beliefs. Here are two recent examples. First, a columnist from the Toronto Globe and Mail. It's time to speak out against religious freedom. For the ardent religious believer in the organized hierarchical religious organization, religious freedom often refers to the right to restrict the freedoms of others or to impose one's religion on the larger world. Canadians are generally further down this path than we are. The British Columbia Bar just voted to discredit a Christian law school because of its rules regulating sexual morality among students, faculty, and staff. In this country, the Colorado Senate passed a civil union bill with no meaningful religious liberty exemption, and the lead sponsor explained why. So what to say to those whose religion requires them to discriminate? I'll tell you what I'd say. Get thee to a nunnery and live there then. Go live a monastic life away from modern society, away from people you can't see as equal to yourself, away from the stream of commerce where you may have to serve them. No living in peace and equality in the same society for him. Religious minorities must conform or withdraw. He had to run for re-election, and he apparently wasn't worried about that, right? For many people, this hostility to religious liberty is a growing intuitive reaction. They're just tired of hearing it from the Catholic bishops and evangelical preachers. For others, it's a more thought-out position. The legal and academic arguments against religious liberty grow more elaborate and more hostile. Arguments created to win a particular battle about contraception or marriage are rarely limited to those issues. These arguments have obvious implications for other religious liberty issues. And if accepted by courts, the precedents apply to all religious liberty claims that come later. I can't analyze all the legal issues today, but I want to highlight the sweep of the arguments that are being made against claims to religious liberty. So the groups now arrayed against religious liberty tend to assume that any interest they care about is compelling, and to state those interests at the grandest level of generality. There is a compelling interest in women's health. There is a compelling interest in non-discrimination. These sweeping claims avoid the proper question, which is whether enforcement of the government's interest as applied to the particular religious claimant and all others who cannot be fairly distinguished is necessary to serve a compelling government interest. Not that that distinction matters, because the opponents of religious liberty also insist that every individual application of their interest is compelling. They say there's a compelling interest in avoiding any inconvenience or affront. No potential customer should ever be referred elsewhere. Avoiding the dignitary harm in being referred elsewhere is a real interest. It is not a compelling interest sufficient to override the harm on the other side of disrupting, or in some theologies, destroying the conscience objector's relationship with his God. The opponents of exemption say there's a compelling interest in having personal services available even when those services are entirely unwanted. No same-sex couple wants a counselor who believes that their whole relationship is deeply immoral. But supporters of gay rights insist that there's a compelling interest in requiring every counselor to be available to same-sex couples, The goal is not to obtain counseling, but to drive conservative believers out of the profession. And the same logic is applied to every other occupation or profession in any way connected to any of these disputes. If you don't want to do abortions, don't work in obstetrics or gynecology. If you don't want to do same-sex weddings, don't be a wedding planner or a caterer or a florist. Washington State and Planned Parenthood are litigating fiercely to require a small handful of pharmacies to stock and deliver emergency contraception, even though years of investigation and test shopping failed to uncover a single woman who could not promptly receive emergency contraception when she asked for it. It's not to solve a problem, it's to drive those small Christian pharmacies out of the profession. And just as all government interests are compelling in this view, so no burdens on religion are substantial. Driving religious minorities out of their chosen occupation or profession is said not to be a burden on religious exercise because their religions do not require them to be a wedding planner or a marriage counselor or a gynecologist. The Supreme Court of California wrote an opinion to that effect. Never mind that excluding Catholics from the professions was a time-honored means of persecution and one that was well known to the founders when they wrote the Free Exercise Clause. We're also told that Catholic teaching on contraception doesn't matter because most Catholics reject that teaching. Some of the deepest disagreements in Christianity have been over forms of church governance. Each side is entitled to its own form, and it is absolutely clear that Catholic institutions are not run as democracies. But never mind, we'll take Catholic teaching from the people and not from the bishops, at least as long as we agree with the people. These arguments are made with no sense of any difference between omission and commission. Failing to provide a service is seen as affirmative harm, even if the service is readily available elsewhere. And these arguments are made with a completely one-sided sense of each side's turf. If we are to preserve liberty for both sides in the culture wars, then we have to preserve some space where each side can live its own values and where its own rules control. Inside a Catholic institution has to be a Catholic space, but not in the view of the church's opponents. If your Catholic institution has employees, or if it has students, it has forfeited its right to live by Catholic rules. If an individual provides any goods or services on however personal a basis or however small a scale, he has crossed over to the other side's turf in the same-sex marriage debate, forfeited his right to exercise his religion. Arguments like these will not easily be confined to the bitter debates over sexual morality. Once formulated, once widely adopted in political debates, once accepted by at least some judges, they will be ready at hand for any other religious liberty dispute that may arise. And these developments are mutually reinforcing with another that I can mention only briefly. Academics have begun to argue that special protection for religious liberty cannot be justified in a society with many non-believers. Now, I fully agree that non-believers have to be integrated into the system of religious liberty and that that task is only partially completed. The rise of a new set of beliefs about religion, a new axis of religious conflict, is a new problem for the law of religious liberty to address. The emergence of a new and more fundamental disagreement about religion makes religious liberty more important, not less. But my point today is more descriptive. Those who are opposed to religious liberty because churches interfere with other people's sex lives are likely to be attracted to this argument about non-believers. It has the potential to get rid of religious liberty once and for all. And those arguing that there is no justification for religious liberty will likely be attracted to arguments designed to minimize religious liberty while it survives. These developments are mutually reinforcing, and they are deeply threatening to the American tradition of religious liberty. I want to leave you with two more personal examples. Last spring, 2 undergraduates filed a Freedom of Information Act request for all my emails with a prominent religious liberty organization, with an Arizona group whose name I didn't even recognize. There was also a press campaign denouncing my work as harmful to gays and women. 2 students were supported and probably instigated by a gay rights group in Berkeley. They were not supported by any of the gay rights organizations at the University of Virginia. Their umbrella group met to discuss this attack, and some of them read my brief in the marriage cases, in which I urged the court to invalidate all the laws that limit marriage to opposite-sex couples, and then to protect the religious dissenters who could not participate in the new rules. And the gay rights groups at Virginia decided that I was okay. I hope that was not their only reason, because by itself that would be the wrong reason. I mean, faculty who oppose same-sex marriage should also be protected from harassing requests for their emails. The law in Virginia actually protected most of the documents they sought, but that would not be true in some other states. I mention this incident partly because it involves academic freedom, and partly because of what it says about the group in Berkeley. Right? It was not enough that I supported same-sex marriage. I was an enemy unless I also wanted to crush all opposition and force religious dissenters to collaborate. Now, this group has nothing like the power of the House Un-American Activities Committee in 1954. This is a very minor incident. Professor Davis is the hero, I am not. But it has the same kind of intolerance as the House Un-American Activities Committee in 1954. The other example is somewhat more encouraging. I represent a Muslim prisoner who is religiously obligated to grow a beard. Arkansas prison officials refused to permit any beard, no matter how short, and many of the liberal religious organizations and the secular civil liberties organizations who had opposed the religious liberty claim in Hobby Lobby supported my prisoner's claim with friend of the court briefs. And that suggests that at least for groups that spend time thinking about these issues, the culture war hostility to religious liberty might be confined to the culture war issues and not spread out to religious liberty more generally. Whether broader opinion will be so discerning, well, that remains to be seen. Many religious liberty issues actually have nothing to do with sex or abortion or non-believers. They have nothing to do with the culture wars, except as the culture wars are eroding support for religious liberty. The United States is the most religiously diverse nation on the planet, and it is pervasively regulated by multiple layers and branches of government. Issues about the free exercise of religion arise whenever one of our diverse religious practices comes into conflict with one of our equally diverse laws or administrative practices. And very often the problem is not some conflict with a competing interest group, but simply bureaucratic rigidity and indifference as in the Arkansas prison system. Even on the hot-button culture war issues, religious liberty provides a model for resolving or ameliorating social conflict. We could still create a society in which both sides can live their own values if we care enough about liberty to protect it for both sides. In all but a tiny fraction of these cases, the issue is not whether any individual can obtain contraception or whether a same-sex couple can have a wedding with the full panoply of catering and flowers and photographs and all the rest. All those things are readily available in the market in most places. The issue is whether the religious conscience objector must be the one who provides those things. Now, as always, abortion is different. Hostile regulation has made abortions difficult to obtain in much of the country, but the statutory conscience protections for medical providers are not a significant part of that problem. Most abortions are provided in clinics, and the pro-choice movement wants it that way. Moving abortions to hospitals will be vastly more expensive. Conscience laws do not affect the clinics because doctors and nurses with conscience objections to abortion don't work in abortion clinics. Abortion is also a special case with respect to live and let live solutions. The pro-life side sees it as killing innocent human beings, and you cannot expect them to be live and let live about that. The moral imperatives on the pro-choice side are equally strong, but access to abortions for women who need them does not require compelling pro-life doctors and nurses to provide them. For the rest of these issues, live and let live solutions would be quite possible if either side would accept them. I obviously cannot tell religious believers what their religion requires of them, but I can sketch out steps that might divert us from the path to a French view of religious liberty. The religious side would have to focus on protecting its own liberty and give up on the goal of regulating other people's liberty. That is, the religious side would have to stop seeking legal restrictions on other people's sex lives. In practical terms, that would mean giving up the fight against gay rights and same-sex marriage now instead of waiting until the fight becomes hopeless. After religious conservatives irretrievably lose on these issues, it will be too late to get specifically tailored protections for religious liberty. Every other form of non-commercial consensual sexual behavior has been deregulated, either de facto or de jure, and religious conservatives have acquiesced, but not until further political resistance became futile. There is no significant lobbying to enforce or reenact fornication laws, adultery laws, sodomy laws, laws against gay and lesbian sex. No-fault divorce is much lamented, but there's little effort to roll it back. Even the effort to restrict pornography has collapsed, with its energies concentrated on child pornography. On all these issues, the churches teach what people morally should do, but they no longer seek to control by law what people may do. On the other side, the advocates of sexual liberty and marriage equality would have to agree to the same basic proposition, that it is far more important to protect their own liberty than to restrict the liberty of religious conservatives. They would agree not to demand that religious individuals or organizations assist or facilitate practices they consider immoral, except, and this is an important exception, except where the goods or services requested are not readily available from another reasonably convenient provider. Same-sex couples should have a right to marry and do as big a wedding as they choose, and women should have a right to contraception, but apart from local monopolies, they have no real need to obtain those things from religious believers with deep moral objections. Corollary of the solution is that Catholic hospitals should not seek and should not be permitted to acquire local monopolies over women's health care. Those who seek to live by their own values should avoid acquiring monopolies that block that same possibility for others. Now, of course, there is no apparent prospect of either side agreeing to live and let live. Each side respects the liberties of the other only when it lacks the votes to impose its own views. Each side wants a total win. And this mutual insistence on total wins is very bad for liberty. The religious side persists in trying to regulate other people's sex lives so long as it thinks it has any chance of success. That motivates much of the other side's hostility to religious liberty. And the other side persists in demanding not only the right to live their own lives by their own values, but also the right to force religious objectors to assist them in doing so. And to that end, they are making arguments that seem likely to destroy religious liberty. Maybe this too will pass. Maybe the courts will do their job and protect the liberty of both sides. You can read the marriage cases in Hobby Lobby as an encouraging example of that. Maybe the sexual issues will eventually be resolved, passions will cool, and a strong core of religious liberty will survive for application to other less emotional issues, or maybe not. Religious liberty is at risk, and its loss would be a loss for America, whatever side of the culture wars you think you're on. And I think I succeeded in leaving some time for questions, and I'm happy to take some.
Thank you, Doug. How would the live and let live solution stand with employers who refuse to hire people because of their sexual orientation?
I think employers are going to lose on that. The question was employers who simply refuse to hire gays or lesbians. And, unlike the employer providing, providing contraception or abortion benefits, simply hiring somebody doesn't really require the employer to do anything that violates his own faith. Now, the kind of claim we might get that I think would be serious, you might get a company like Hobby Lobby saying, we won't provide spousal benefits to same-sex couples. Catholic Charities in D.C. Has eliminated all its spousal benefits with a grandfather clause for people who had already been hired before same-sex marriage came to D.C. But new hires don't get spousal benefits at all because they refuse to provide spousal benefits to same-sex spouses. That could be a live issue. I think that a simple refusal to hire is not a live issue in many places and would get pretty short shrift from the courts. Yes, sir.
Could you explain more about the controversies in Texas over the regulation of the abortion clinics more or less out of existence by demanding various things of them? It seems to me that, if I just might, that the founding fathers defined corruption in part as using public office for private gain. That the Texas officials who connived at this set of regulations are, evangelicals, and they are imposing on the entirety of the Texas population, more or less, a ban on accessible abortion. And at least one court, as I understood it, found that their requirements were unreasonable and so forth. But anyway, as I understand it, also Mississippi has more or less no abortion clinics. But this is clearly a very aggressive and very successful imposition on the entire state of narrow religious views.
Right. So the Supreme Court has said government need not be neutral as to abortion. They can discourage abortion, but they cannot substantially burden the right to choose abortion. So what does that mean? And red states have been pushing the envelope further and further, and the Supreme Court has upheld some pretty burdensome stuff. They have not upheld anything nearly as burdensome as what you just described. So the requirement that abortion clinics be built to the standards of outpatient surgery centers requires expenditures of very large sums of money, and many of the clinics simply don't have it. And the requirement that your doctors have admitting privileges in nearby hospital is subject essentially to political veto by the community. Now, the conscience legislation says those local hospitals can't discriminate because he provides abortions, but enforcing that is obviously difficult. So these have shut down lots of clinics. The Fifth Circuit, which includes Texas, is very conservative, preliminarily upheld those laws. The Supreme Court has stayed their enforcement. And I think there's a good chance the Supreme Court will eventually strike those down, as they're clearly intended to and have the effect of shutting down most abortion clinics. We'll see. Unfortunately, as so many things do, it comes down to Tony Kennedy. It's not a good way to run a legal system, but that's the legal system we have. Yes, sir.
Back to your comment on the history, you suggested that unlike France and the United States, religious institutions were mostly on the side of liberty. Do you disagree that American religious institutions have taken the side of powerful minorities, for example, in the past in labor struggles or more recently on environmental issues?
No, I don't disagree with that. Religious organizations are often on opposite sides of political issues, but the perception in America, particularly in the 19th century, was that the churches were on the side of liberty. And Tocqueville talks about this and how sharply it contrasted with France. And in large part that was because, with a couple of exceptions, they had strongly supported the revolution. The New England pastors preached revolution from the pulpit. Now, both here and in Europe, and that's a large part of what I was talking about. Conservative churches are sometimes on issues that progressive, on the conservative side of issues, and progressives view them as opposed to liberty in important ways. And I think to some extent that's right. And to the extent that it's more right today than it used to be because of these sexual issues, that's why I think it's endangering our tradition of religious liberty. But that tradition grew up at a time when the great bulk of the people perceived the churches as on the side of the people's liberties.
Forgive me, I'm not a lawyer, so I may not understand all of these issues, but it seems to me there are two different kinds of things that you've been talking about, one of which is the issue of public accommodations, but the other of which is the imposition of certain kinds of religious criteria upon civil processes. So with same-sex marriage, really up until a couple of years ago, in almost every state in the Union, one could not, a same-sex couple could not acquire a civil marriage basically because religious criteria for what marriage is supposed to be were restricted that legally in most states. And in fact, Michigan is still one of the states where one cannot have a civil marriage. It seems to me, first of all, that this is a situation of religious discrimination because some denominations were perfectly happy to marry same-sex couples, but their marriages were not given the same recognition by law as those denominations which would not do so. But that's a separate issue. But I think that's part of where the heat comes. That's the major part of where the heat comes in the debate over same-sex marriage, not from whether or not you can get the florist to give the flowers for your wedding. But I think there is an issue with public accommodations that concerns me here. There are religious organizations that, as part of their religious belief, think that Jews and black people are subhuman. Do they have the right then, because of their religious beliefs, to discriminate if they're doing a business that basically is a public accommodation and caters to the public, to refuse to serve Jews or African Americans because of their religious, in other words, is a religious exemption justified in those cases?
No. I mean, those are not real cases. We haven't had a case like that in decades. And if we get one, I'm fairly confidently predict that they would lose. That's a judgment about how the courts react and what they would think is a compelling interest. Now, the bigger question you ask is important and complicated and probably by this point insoluble. But we have totally commingled religious marriage and legal marriage. Talk about separation of church and state. There's no such thing with respect to marriage. So, clergy people perform legal marriages. Secular courts dissolve religious marriages for Protestants, not so much for Catholics and Orthodox Jews who insist that you're still religiously married even if you're civilly divorced. But we have so totally integrated the religious institution of marriage with the civil institution of marriage that most Americans barely distinguish them. And that's why when the state comes along and starts changing the rules of civil marriage, many religious folks see it as messing with a religious institution. At some level, they know that they're different, but they think that the legal civil marriage is resting on a foundation of religious marriage, and the religious folks should get to define it. And they were happy with that arrangement as long as the entire society accepted their definition, right? Well, they lost big time with no-fault divorce. We changed the way that you end a marriage, and most Protestant denominations accepted that because they didn't have an alternative structure in place. They didn't like it, but it didn't generate the same kind of heat as this change, which permits same-sex marriage. And so I do think that's where the heart of the resistance to marriage equality comes from. It's this belief that marriage is essentially a religious institution, the state is messing with it. And after the Massachusetts decision in 2004, the first one to constitutionally require marriage equality in a state, President Bush said they are messing with a sacred institution. Variations of the word sacred appeared 3 or 4 times in his statement. So that is where most of the heat comes from. But as the gay rights side is winning and same-sex marriage looks like more and more it's going to happen, the heat is very much shifting to these dissenters like the Forest. And the gay rights side is not unanimous about that. There are people who would exempt them or let that fight go by. But that's generating plenty of heat too, actually. And there are cases pending in various state trial courts around the country.
But if I may ask, when I was a kid, the Catholic Church, it seems to me, made a distinction between civil marriage and divorce and religious marriage. Yes. And they were very comfortable with that. In other words, you could get civilly divorced, and the church did not recognize that, but they did not try to change the definition of civil divorce. And I think the whole debate over the legal regulation of same-sex marriage has really been a reversal of that, where churches have, I do understand that there's been a mix in the U.S., certainly not the kind of mix that they have in Britain, where the Church of England had to have separate ceremonies for marriage, for example, for Quakers and Jews, because it was a state church. Nonetheless, there has been a way of mixing these things, but many religious organizations have distinguished their procedures for validating or invalidating a marriage from the civil ones. And that was not the case with same-sex marriage, where religious organizations really did very actively and aggressively try to to restrict the definition of civil marriage in such a way that same-sex couples could not access it.
Well, that's right, but I don't think it's different. I mean, the Catholic bishops refused to recognize civil divorce. They said you're still married until you get an annulment from the court. But they also very much tried to influence the rules for civil divorce, right? And they lobbied hard against no-fault divorce. I think, internally to Catholicism, if you've got a divorce but not an annulment, you are civilly married or civilly divorced but religiously married. And similarly for Orthodox Jews if you don't have a get. But I think for most of their friends from outside the church, they're divorced and they're just having a problem with their church. As a society, we do not distinguish civil marriage from religious marriage. And it would take generations to undo that and get people to really think of them as separate because we've so totally commingled them. So the religious attempt to control the civil definition of marriage is not new. It may be especially intense in this fight, but there's nothing new about it. Yes, ma'am.
I'm interested in considering potential conflicts of religious conscience between employers and employees with respect to abortion provision. So if a hospital says for its religious conscience that it doesn't want to facilitate abortion, what about a doctor who has a religious conviction he has to save the mother and, you know, the woman comes in there, it might have been ambiguous or not clear, but she needs assistance. Could he claim his own religious liberty exemption to perform an abortion?
Well, I mean, my answer is, in an emergency, he's got to do what's right for the patient if he's the only one around. That's what this Benton Harbor case is really about. And you know, whether it's easy to imagine these cases where there's only one doctor around. They don't happen very often. When they do, I think he's got to take care of the patient. They happen sufficiently rarely that we don't have court decisions. This Benton Harbor case may produce a court decision. We don't have any yet that I'm aware of.
So in the case where a Catholic Church does have a de facto local monopoly,
right?
You know, what can be done?
What can be done? Well, you know, some cities have worked out very creative solutions. So, you know, in Austin, Texas, the Catholic Church, well, not the church itself, the Daughters of Charity, which is an order of nuns, own and run the hospital that used to be the city hospital that provides all the charity care. They got a list of things they won't do. The county health, coordinated health authority has arrangements in place, so all those things are available at another hospital or at community clinics depending on the intensity of the service. The Daughters of Charity are willing to let the docs in their hospital make referrals, tell people what their options are, what else is available. If you got a bishop willing to work things out, you can do that. In some places, we do not have bishops willing to work things out. And you know, there is a federal obligation to provide emergency care. In the ethical codes of most professions, there is an obligation to refer if you can't do it yourself. I mean, the reason they never found any woman in Washington State who couldn't get emergency contraception was that the pharmacists who wouldn't do it themselves would tell women where to go, where they could obtain it. So if you have someone taking what appears to be, and I have to say I'm not sure of this, I'm no expert on Catholic theology, but what appears to be the hardline Catholic position, that no matter how endangered the pregnancy or how hopeless it is, or what risk to the mother, we can never terminate a pregnancy, then I think you can't let them have the only hospital in town. And economically, that is difficult. I mean, one reason they own so many hospitals is that hospitals have been merging. Yes, sir.
I was wondering about the Sweet Cakes decision, which is from Oregon, I believe. Does Hobby Lobby set a precedent for that case, or does it not? And as far as, can that bakery owner claim a religious exemption from the lawsuit that's being brought against him?
Right. So there are a handful of these cases around the country involving bakers, florists, wedding photographer in New Mexico who lost in the state Supreme Court, got a lot of publicity. Most of them have not progressed very far yet through the court system. Those cases are a bit harder than Hobby Lobby because in Hobby Lobby, the alternate provider, the insurance company, was already in place, and the government had a system to make sure that they actually provided. The baker in your Oregon case refused to make a wedding cake for a same-sex wedding. There are plenty of other bakeries. This wasn't a small town. But you got to go there. And, the gay rights side says, it's humiliating, it's embarrassing to go in and be told, we won't serve you here. So that's a harder case for courts. I think, as long as they're not gratuitously abusive about it, that's a different thing. But if they simply, simply say, for religious reasons, we don't do same-sex weddings, and, there are plenty of other bakeries in town, I think they ought to be protected. I'm not optimistic that they will be. And in part because this issue only arises in states sufficiently sympathetic to gay rights to have passed a strong public accommodations law. And in those states, the climate for considering these objections from religious conservatives tends to be kind of hostile, and in some places seriously hostile. So I think those cases are going to be hard for these merchants to win, but there's one in Oregon, there's one in Washington State, there's one in Colorado. They won't all go forward to a judgment, but some of them are in state administrative agencies, some in state trial courts, but we'll be getting decisions on that question over the next year or two. Yes, sir.
You opened up your talk with the conception, both in our law and probably in our public moral and political imagination, of the fact that certain actions which are either flowing directly out of or absolutely essential to our personhood or identity are protected as essential liberties. And you see this sort of language and this sort of logic in the abortion and sodomy decisions in Casey and Lawrence. Right. But the case you mentioned where the court was able to sort of duck the major decision, the Martinez case about allowing a religious group on campus to exclude members. The court didn't reach the heart of the argument, but there were some very interesting lines from Justice Ginsburg where she reaffirmed the absolute connection and the inability to separate gay actions from gay personhood, right, homosexual identity, and that makes absolute sense. But then later, she's able to separate Christian action not just from Christian identity, but from Christian belief. So rightly, homosexual conduct is homosexual being and personhood, but Christian action is now 3 steps removed, and it completely separates Christianity or religious belief from identity. So do you think within the religious context, action and personhood are going to be able to be linked again? And if so, is that a legally soluble action? Is that something that has to happen through legal argument, or is it something that's already happened in public argument and the law is just downstream of it?
Right. Well, I mean, you're exactly right about the Ginsburg opinion in that case. This is another place at which this appears to be a mirror image set of arguments. So folks on the religious side say, look, we don't discriminate on the basis of your sexual orientation. It's only your sexual conduct. We don't care how you feel or how you identify. It's only your sinful conduct that we want to restrict. And to the gay rights side, that is absolutely preposterous and ridiculous, right? Our sexual orientation is protected as long as we remain celibate. What kind of a rule is that? But the gay rights side says exactly the same thing to the religious side. Right? You can believe whatever you want. We would never think of interfering with that. You just can't act on it. And in a particular context, Justice Ginsburg did sort of buy into that distinction. And she said, we couldn't do this to churches, but we can do it to the student religious organization because they want to take advantage of the university facilities. They want access to the university forum. So they're trying to get something, and that can be conditioned, and we can separate out their conduct from their belief. I don't know if she would extend that any further. I don't think she would. But it's troubling enough for her to do it there. And that won't be the last word on these issues. But that's very much an issue in the claim for religious exemption. And I do think it's parallel. And a believer can no more fail to act on what she thinks God demands of her than a gay person can fail to act on his sexual orientation. Yes, sir. You got it.
Hi. I'm speaking as a non-believer, and the concern for someone like myself is that because I see there could be as many definitions of what God wants someone to do as there are people, because to me it's all a human contrivance. So what is the the legal standard, or what's the state's standard for judging what counts as a real religion or what counts as a legitimate claim? Because it seems what we talked about most to this point are major religions and major groups that have political power making claims. And so I'm just wondering how that plays out, and then doesn't that get the state in the business of choosing and selecting and saying what's a real religion and what's not, and what counts and what doesn't? And then how can we have the state be more neutral in those arguments, which would be my preferred position, is to have the state stay out of it and not take a position, just remain neutral and have a guaranteed secular state that provides this equal judgment for everybody.
Well, as a non-believer, you've been heavily protected by religious liberty. There are plenty of people who would, in the past, who would have been happy to persecute you, and not so distant past either. There's embedded in your question an assumption about what neutrality means, right? That neutrality just means we'll impose the same rules on everybody, no exceptions. Well, if one side gets to write the rules, that's not very neutral, right? Religious side says, we don't make exceptions for gays. It's neutral to enforce the rules against everybody, and it just happens, and what they do is illegal. And when the religious side wants an exemption, they sometimes get the same answer. They got that answer from Justice Scalia in 1990 in a case called Employment Division versus Smith. We apply the rules to everybody. It's neutral, no exceptions, no matter how hostile the underlying rule is to your faith commitments or how great a burden it imposes. There's another way to understand neutrality in this context, which is the government is most nearly neutral towards religion when it minimizes the extent to which it either encourages or discourages people from acting on their religion. And that's also neutral, and that leads to a very different understanding in which, because if we say to people, look, you're going to be fined or imprisoned for practicing a religion, that is obviously a powerful discouragement. If we exempt those people, we say you get an exception from this rule, that's usually not much of an encouragement. You're not going to go out and become Jewish just because it's legal to keep kosher. You're not going to keep your kid out of school just because the Amish in Wisconsin got an exemption. Now, sometimes that's not true, right? If we had a religious exemption for people who were religiously opposed to paying taxes, the entire Republican Party would convert tomorrow, and lots of Democrats wouldn't be far behind. So if the exemption that is claimed aligns too closely with your secular self-interest, well, then granting it may encourage religion and not be very neutral. But for the most part, exempting these religious practices is neutral in the sense of not discouraging religion and not encouraging religion. Now, where your question began about how do we know who's real, yeah, that's a genuine issue at the margins. I will tell you, when I do seminars on religious liberty, there's always at least one student paper on what's the definition of religion and who counts. But I've been working in this area for 35 years now. The number of real cases where that's in doubt is extremely tiny. There are some. But the great bulk of these cases, everyone would agree this is a religion. Everyone would agree it's a religious practice. And the question is whether they're entitled to exemption and whether they're doing any harm to anybody else if we grant them the exemption. I'll be around for a few minutes. Thank you all very much.
The University of Michigan Senate's annual Davis Markert Nickerson Lecture on Academic and Intellectual Freedom is supported in part by contributions by the public to the Academic Freedom Lecture Fund and might qualify for both Michigan as well as federal income tax deductions. If you wish to contribute to the fund, checks should be made payable to AFLF and mailed to Post Office Box 4152, Ann Arbor, Michigan 48106-4152. Alternatively, checks may be made payable to the University of Michigan AFLF and mailed to the same address. These latter contributions will be invested in a University of Michigan account entitled Academic Freedom Lecture Fund, which is under the joint stewardship of both the University of Michigan Senate Advisory Committee on University Affairs and the Board of Directors of the Academic Freedom Lecture Fund. Individuals who contribute become members of the Academic Freedom Lecture Fund and will receive information about activities sponsored by the fund. The Academic Freedom Lecture Fund is a Section 501c3 nonprofit organization. All contributions to it are tax deductible under IRS regulations.